As we approach the final technical session of the day, we turn to a subject that lies at the heart of effective arbitration, the interim measures. A question often arises, who protects the parties while arbitration is still underway? Commercial disputes cannot always wait. Assets may disappear, evidence may be lost, and contracts may be frustrated. It is to address these realities of Arbitration and Conciliation Act that provides the remedies under Section 9, 17, and Section 37, laying down the appellate framework. Every lawyer has the same point. Believe that the client's matter is so urgent that it cannot until tomorrow wait. Yet the law demands more than urgency. It demands a sound legal foundation. Today's session will explore where those legal boundaries lie and how courts and tribunals balance urgency with principle. To preside over this important discussion, we are deeply honored to have with us Honorable Justice Manish Pitale, Judge of Bombay High Court. Justice Pitale's profession journey reflects a rare blend of academic distinction, extensive advocacy, and judicial scholarship. Justice Pitale is a distinguished judge of Bombay High Court with wide-ranging expertise in constitutional, arbitrational, commercial, and civil and criminal law. After graduating from University of Delhi and its Faculty of Law, he enrolled as an advocate in 1995, trained under senior advocates, and later practiced independently before the Supreme Court of India. Justice Pitale was elevated as an additional judge of Bombay High Court in 2017 and became a permanent judge in 2019. His career reflects exceptional legal scholarship, judicial acumen, and an enduring commitment to the rule of law. We are truly privileged by His Lordship's gracious presence. May I request Honorable Justice Manish Pitale to kindly take the chair. Ladies and gentlemen, Justice Pitale. I will request my co-chair to now introduce the co-speaker.
It is now my privilege to introduce our distinguished speaker, Shri Nitin Thakkar, Senior Advocate, is one of the most respected members of the Bombay Bar and presently serves as the President of the Bombay Bar Association. With over 5 decades of distinguished practice before the Bombay High Court, he is renowned for his expertise in commercial and banking law and has also served as an arbitrator and mediator. A committed leader of the bar and mentor to generation of young lawyers, he has been honored with several prestigious awards, including the Attorney General Soli Sorabji Award for his outstanding contribution to legal jurisprudence and bar leadership. His distinguished career reflects excellence in advocacy, unwavering integrity, and a lifelong commitment to legal profession. Ladies and gentlemen, please join me in extending a warm and respectful welcome to Shri Nitin Thakkar, Senior Advocate. Please have a round of applause.
Interim relief is often described as temporary. Its consequences, however, frequently anything but temporary. An order passed at the threshold of an arbitration can determine whether the arbitral process remains meaningful, whether rights are preserved, and indeed whether the eventual awards retains practical value. As practitioners, we all have heard familiar questions. Should we file under Section 9 or under Section 17? If today's session leaves us with a clearer answer to that question, we shall return to our chambers considerably wiser. May today's deliberation deepen our understanding of the distinct yet complementary roles of Section 9, 17, and 37, and reinforce the importance of timely judicial and arbitral intervention in preserving the efficacies of arbitration. With great respect, I request Justice Manish Pitale to kindly assume the conduct of proceeding and invite our distinguished speaker to deliver his address.
Good evening to all of you. I think it was day before when Mr. Thakkar said, no, I'm here in the capacity as a member of the AAWI. So that was a revelation for me. And I'm really happy that the AAWI has taken the initiative to organize this kind of a day-long workshop for arbitration. And tomorrow I'm told there's a workshop for mediation as well. Because arbitration is sometimes mistakenly believed to be the preserve of members of the bar who are having practice on the commercial side. But arbitration as an alternative dispute redressal mechanism is now being encouraged in all aspects, not just the commercial disputes. Of course, the focus is on commercial disputes, but even otherwise, if disputes can be settled by way of arbitration instead of the classic court litigation, then the court's burden is lessened, and it really helps the judges as well as the bar to concentrate more on mainline litigation. Today, I saw the schedules that were fixed for the day-long workshop. It started, I believe, with taking stock of the arbitration law in India, and then on specific topics. This session in the evening is for sections 9, 17, and 37 of the Arbitration Act. We've done a bit of a division of labor. Mr. Thakkar is going to speak on section 37, and I'll be speaking on sections 9 and 17 of the Arbitration Act. I don't have to tell all of you that 9 and 17 pertain to interim measures. 9, insofar as the court is concerned, section 17, the arbitral tribunal. But before we go to these two sections, let us see the background in which the 1996 Act itself was enacted. The Arbitration Act 1940 was in vogue, and the basic difference or the journey from the 1940 to the 1996 Act is the difference in the role that the court performs insofar as arbitration proceedings are concerned. If you look at the earlier statute, you will realize that the court had more the role of a controller or a supervisor of arbitration proceedings. And in the 1996 Act, and particularly after its 2015 amendment, the role of the court is more of a facilitator and an agency that assists and encourages the arbitral proceeding. So in that spirit, when these two sections are seen, as was observed by the Supreme Court in the case of Sundaram Finance versus NEPC, a 1999 judgment, that sections 9 and 17 or any statutory provision akin to this was not found in the 1940 Act. In the 1940 Arbitration Act, when a party applied under section 20 for appointment of an arbitrator, simultaneously it could apply under the second schedule read with section 41B for interim measures. That was quite different from sections 9 and 17 specifically provided in the 1996 statute for interim measures. Now, we are supposed to discuss the difference between the two sections, which are quite obvious, but I will also talk about certain similarities between the two, especially after the 2015 amendment. But before we go to that, when we talk of interim measures under both these sections, the classic three-pronged test applies. What we learned basically in civil law about Order 39 Rules 1 and 2 of how interim relief is to be granted or rejected by the court, the three-pronged test of strong prima facie case, balance of convenience, grave and irreparable loss to be suffered by the applicant if the relief is not granted. These still continue to be the classic test that is applied by the court under Section 9 and the tribunal under Section 17 when an application for interim measures is taken up for consideration. So applying these, the court or the tribunal comes to a conclusion whether interim measures are to be granted or not. Now, sections 9 and 17 both have undergone a major change in the 2015 amendment. So before comparing the two, we must first look at their earlier avatar and what they are right now. If you look at section 9 pre-2015 amendment, you will find that subsections 2 and 3 were absent, and section 17 is virtually substituted by the 2015 amendment. Now, this was required because of the experience that we had as as courts, as litigators, the lawyers, the parties, it was realized that somewhere a push was required for the arbitral proceeding to be encouraged, which is the whole object of the 1996 Act. And therefore, the 246th report of the Law Commission deliberated upon it and suggested certain amendments. Now, pre-amendment, if you see, due to absence of subsections 2 and 3 in section 9, certain problems were being faced. And insofar as section 17 pertaining to the powers of the tribunal was concerned, it was found that in a way it was a kind of a toothless power, because there was no way in which the interim order of the tribunal could be enforced. Perhaps at that stage, the parties had to rush to the writ court or some other remedy, which was again going against the whole grain of the 1996 Act. So therefore, section 17 was substituted to add subsection 2. Subsection 1 was virtually made a mirror image of section 1 of the amended section 9 of the Arbitration Act, giving wider powers to the tribunal, identifying wider powers in the tribunal, specifying that the power can be exercised during the course of arbitration, and subsection 2 gave it teeth, so to say, by saying that an interim measure or an order of the arbitral tribunal can be enforced as if it's an order of the civil court under the CPC. So this basic difference between the pre-amendment avatar and the subsequent and the present form of sections 9 and 17 is also important to understand the difference between the two. Now, if you look at section 9, of course, the basic difference is that the court exercises power under section 9 as opposed to the tribunal under section 17. And under section 9, the court can exercise the power before the arbitral proceeding is initiated, during the course of arbitration, and even after the award is rendered before it is enforced under section 36. While under section 17, the tribunal can exercise power, obviously, only when the arbitral proceeding is alive and it is under consideration. These being the differences. Now, let us look at if there is an overlap somewhere between the two. And it is obviously at the stage when the proceeding is still pending before the arbitral tribunal. Now, you would wonder that if wide-ranging power, mirroring what the power is given to the court, is now bestowed upon the tribunal, why is this overlap still provided? And you realize that there are certain circumstances where the power of the court would have to be invoked, even when the arbitration proceeding is still pending before the tribunal. There have been circumstances noticed by the courts that when a remedy becomes, or a prayer for interim measure becomes inefficacious, so to say. This is with reference to subsection 3 of section 9, which is added by way of amendment. I'll just refer to it so that you get a perspective or a background on which I'm speaking. Now, subsection 3, which is added by amendment, says, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious. So one is, of course, a ban on the court entertaining an application for interim measures when the tribunal has been constituted. But two, there is an exception which is carved out, which indicates that when it becomes inefficacious to seek an interim measure from the tribunal, the court would still be retaining its power to grant an interim measure. Now, there are two cases, at least, that have been noticed by the Bombay High Court, where this exceptional power was exercised. One is Girish Mehta versus Mahesh Mehta, 2009 SCC Online, Bombay 1986, where it was noticed, even before the amendment was brought about, that there could be a situation where during the pendency of the proceeding before the arbitral tribunal, an interim measure becomes necessary against a party which is not party to the arbitral agreement. Now, there could be a situation where unless such interim measure is granted, the whole purpose of pursuing the arbitration proceeding is frustrated. In such a situation, our High Court has held that the court can exercise power even during pendency of the arbitral proceeding before the arbitral tribunal. The other is a 2017 case, Shakti International versus Excel Metal Processes, where a party was able to convince the court that in circumstances that arose in that case, unless the court receiver of the Bombay High Court is appointed as a receiver on the property in question, the whole purpose of the arbitration will be frustrated. In that case, despite the arbitral tribunal being constituted, despite the opportunity to the party to approach the arbitral tribunal under Section 17, it was found that the remedy was inefficacious, and therefore an application under subsection 3 of Section 9 was held as maintainable. So there could be situations where exceptions are carved out and the court entertains such applications. Now, one of the questions that arose before the Supreme Court was in the case of ArcelorMittal versus SR, where the question was that an application for interim measures was filed before the court under Section 9, and thereafter the arbitral tribunal was constituted. So what could be the option available to the court? Is it that during the pendency of a Section 9 application for interim measure, the moment the arbitral tribunal is constituted, the court becomes powerless? Is that the situation? Because that was the argument that was advanced before the court. And because the words used are, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1. So what about an application which is filed in pending and the arbitral tribunal is constituted? So in ArcelorMittal, the facts were that the application was not just filed, but it has reached the stage of it being reserved for orders. Arguments were completed, order was reserved. And the question arose, what is to be done? Is the court to just have a hands-off policy, say that because the whole object of this amendment of 2015 is to encourage arbitration and that the arbitral tribunal should decide all disputes? Should the court have a hands-off policy? In the said judgment on facts, the court found that in such a situation where the court has applied its mind, gone to the stage of even reserving the order, then there is no point in telling the court that you can't exercise your power. So it still is a gray area according to me, because when do you say the court has applied its mind? Now you file an application under Section 9. If it is at the filing stage, it's a very simple answer that the court has really not applied its mind, so let it be sent to the arbitral tribunal. Sometimes it happens that when a Section 11 application is filed and a Section 9 is also filed, and the arbitral tribunal is constituted in a Section 11, the court says that we'll convert your Section 9 into a Section 17 and go and argue there. But even in that situation, can the court, if it is alive to the fact that a limited interim relief is required, unless you preserve the situation on that day as it stands, the whole purpose of referring the parties to the arbitration will be frustrated, would you still not exercise power? So it's still a gray area, but we can broadly say that where the court has considered the controversy, it has applied its mind, then the court cannot be told that you have to hold your hands just because the arbitral tribunal has been constituted. So the interplay between 9 and 17 have brought about such interesting cases before the Supreme Court. There's also one aspect which I came across, because I am making this presentation more or less on an ad hoc basis, because I just was mentioning to Mr. Thakkar that through the day our panel was conducting some interviews. So the bar members had been kind enough to give me this thick volume to assist me in making this presentation, but I couldn't go through it at all. So I thought I'll just make some handwritten note with a bare act in my hand, and I'm doing exactly that. I'm reminded of my days at the bar in the Supreme Court, situations where you are briefed at the 11th hour in the court, and then you go through the papers and make some kind of a submission before the court. So I'm having those feeling of deja vu. It's a presentation before all of you with this bare act in my hand. But I out of interest, I was looking at some judgments a few days ago on issues pertaining to arbitration, and I found a very interesting judgment on the interpretation of subsection 2 of Section 9. Now, there's a huge controversy on this. There are some divergent views of various high courts. And the Supreme Court, in the context of a dispute that arose from Karnataka, has given an indication how you have to read subsection 2 of section 9. And I think it should be generally applied. It has been applied in the context of rules framed by the High Court of Karnataka. But the background is this, that if you look at subsection 2 of section 9, a very important facet has been introduced by the amendment, and it reads, where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceedings shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. Now forget the further time. If we look at the 90-day window that is given, and the words used are that the arbitral proceedings shall be commenced within a period of 90 days. So the corollary should be that, because the whole purpose is that if a party approaches a court under section 9(1) and is able to obtain interim measures, an order for interim measures, it would be in the interest of that party, if it is not fair to the other side, to not initiate arbitration proceedings at all. So on the one hand, it approaches the court on a promise that our dispute, which we have agreed to be resolved through arbitration, we will be resolving, but till then please give me these interim measures. The court is impressed, grants the interim measures, the party doesn't go to arbitration. So what is the solution for that? That is subsection 2, which enjoins that the arbitral proceeding must commence within 90 days. But unfortunately, the subsection does not provide for a consequence of the arbitral proceedings not being commenced within 90 days. Now, there's a judgment of the Supreme Court, recent judgment. It's called Regenta Hotels Private Limited versus Hotel Grand Center Point, 2026 4 SCC 142, where a dispute arose from Karnataka. And the Supreme Court took aid of rules framed by the High Court of Karnataka in the context of section 9, where the rule provided that if the arbitral proceeding is not commenced within 90 days, the order of interim measure shall lapse. So that's a consequence that is read by the court, taking aid of the rules that are framed by that High Court. But I am of the opinion that this should be applied across the board, rules or no rules, because a consequence has to follow. Because if you don't provide for the consequence, the whole purpose of introducing this amendment of adding subsection 2 is frustrated. Now, therefore, the whole purpose is, one, you have decided as parties to have your dispute resolved through a private tribunal, through arbitration. Two, you have been able to convince the court that till the arbitration commences, I need an interim measure urgently, which the court is convinced and grants you, but it's on a promise that within 90 days, you will ensure that arbitration is commenced. Now, in this judgment, what would be commencement of arbitration is also commented upon, and it is, of course, based on the statutory provision of section 21. This is important because sometimes some courts perhaps have taken a view that commencement would be when a section 11 is filed before the court for appointment of an arbitrator. The Supreme Court says that you have to look at section 21 because commencement of arbitration as per the provisions of the Arbitration Act is when a notice is issued by a party to the arbitration agreement to the other side, showing its intention to initiate the arbitration, and it is received by the other party, the arbitration commences. So this exercise of issuing notice and ensuring that it is received by the other party shows that the arbitration has been triggered. So the party which is able to obtain an order of interim measures from the court under section 9(1) must ensure that arbitration commences under section 21 by the other party receiving a notice for commencement for initiation of arbitration on the part of the party that has an order of interim measure in its favor. I think this is how we have to read it to take the object of this 2015 amendment forward. There's one more interesting judgment that I came across, again in the context of section 9. We had, the Bombay High Court had rendered a judgment in the year 2013, which was holding the field till recently. It was Dirk India Private Limited versus MSEGCL. And this position of law was followed by Delhi High Court and various high courts, where it was authoritatively held that in the post-award scenario, who can maintain an application under Section 9 for interim measures? the successful party or the unsuccessful party. There was a distinction drawn by the Bombay High Court, Delhi High Court and other high courts that when a party is unsuccessful in arbitration, it is not entitled to knock the doors of the Section 9 court. The logic perhaps being that because you are unsuccessful in the arbitration, you would be impelled to challenge the arbitral award, and the channel is Section 34. So when you approach the Section 34 court, you would be obviously also applying for interim orders, interim measures. So that is the forum for you. And as an unsuccessful party, you can't knock the doors of a court which is assigned with the Section 9 petitions. But the Supreme Court in the case of recent judgment in the case of Home Care Retail Marts versus Harish Sanghvi, 2026 SCC Online SC 670, has held that the line of judgments following Dirk India Private Limited, Bombay High Court, Delhi High Court and so on, do not lay down good law, because there is here an artificial distinction being drawn by the courts between a successful party and an unsuccessful party. The Supreme Court has emphasized on the use of the expression, the word party in Section 9. It looked at subsection 1 and said the words, the opening words are a party may before or during or at any time after the arbitral award has been made, to approach the court for interim measures. Now, the Supreme Court says that a party is a party as defined in the Act, which is party to the arbitral agreement. So the high courts were wrong in making a distinction between a successful party and an unsuccessful party. So therefore, it was laid down that even if a party is unsuccessful in arbitration, it can still go to the Section 9 court and call for interim measures during the time in which it is perhaps challenging the award under Section 34. The Supreme Court points out that another reason why this is a line that we should take is that a party can be partly successful and partly unsuccessful in an arbitration. So therefore, to label parties in this two distinct manner is not justified, and therefore the law that is now laid down is that a party that is unsuccessful as well as the other party which is successful, both can knock the doors of a Section 9 court for interim measures under Section 9, even in the post-award scenario. There's another angle which is explored by the Supreme Court in the judgment of Alka Chandevar versus Shamsul Ishrar Khan, 2017-16 SCC 119, where the focus was on Section 17(2) of the amended provision. Now, as I said that the 2015 amendment bodily substituted Section 17, and subsection 1 thereof actually mirrors the powers that the Section 9 court exercises. But Section 17(2), subsection 2 was a novelty because it specifically provided that an order of the tribunal on interim measures, subject to, of course, an appeal under Section 37, is an order to be treated as an order of the civil court, which is enforceable as if it's an order of the court under CPC. Now, what is the efficacy of this provision, and how is the court to read it? And this was analyzed in the context of an order, an interim order or an order of interim measures passed by the tribunal, and which was sought to be enforced on the one hand, and on the other, the party took recourse to Section 27 of the Arbitration Act. Now, if you look at Section 27, the marginal note can be a little misleading. 27 says court assistance in taking evidence. So the impression in the first blush is that this is only for assistance for taking evidence, assistance to the arbitral tribunal, etc. But if you see subsection 5, it makes an interesting reading, because it says, persons failing to attend in accordance with such process meaning for evidence, etc. But the crucial words are, or making other default, or refusing to give evidence, etc., shall be subject to the disadvantages, penalties, and punishments by order of the court. So this, in a way, is a power akin to calling upon the court to exercise its power of contempt, and therefore, reading sections 17(1), interim measure passed by the tribunal, 2, where it is enforceable under the CPC as an order of the court, and also 27(5), where you can reach out to the court and say that this is the order on interim measure, this is the default that is committed. So please treat it as a contumacious conduct on the part of the party which has defaulted. So this is how the court is reading all these provisions together. The whole intention being that be it an order of the court under section 9 or the tribunal under section 17, it has to be enforced, it has to be given its due respect, because the efficacy of the arbitration process itself should not be diluted. Now, the whole purpose of the 1996 Act, as I indicated, is that not only to encourage arbitration, but to indicate that the court shall not interfere for the asking, the court shall not exercise power of control, the court shall not exercise power of being a big brother and supervising each and every stage of the arbitral proceeding. On the contrary, the court will be a facilitator, the court will be assisting the arbitral tribunal to reach the whole object with which, or the purpose for which the Arbitration Act of 1996 has been enacted. But I have said this earlier in different fora, that the object, purpose, etc. is fine. But in our setup today, in India, the purpose or the object of the Arbitration Act in a large measure has been frustrated because of lack of understanding on the part of all the stakeholders, including the court, I would say. Because sometimes, the judges are wearing different hats. Your assignments change. If you're sitting on the original side, you are performing a different kind of role. You come on to the appellate side, you come on to the writ side, you're performing a different kind of role. I am reminded, say about a year ago, when I was sitting on the original side and a very hard-fought matter was being finally heard, because I had ensured that some old suits are taken out for final hearing. And the senior counsel who were appearing there, one of them, he was very pointedly, he said, and correctly said, I thought, that, sir, before we open our arguments on this side, please be conscious of the fact that you are deciding an original proceeding and you are not sitting in writ jurisdiction. Because this is what happens. A writ court has its a different kind of power. An original suit is to be tried in a different manner. So when you are changing hats, the court has to be conscious and responsible what the purpose of the Arbitration Act is, how you generally should have a hands-off policy, and also remember your role as a facilitator, as a body that assists the arbitral tribunal. At the same time, the arbitrators should be conscious of the fact that they are exercising a different kind of power. They are not sitting as a classic court to go into hair-splitting arguments. They have to look at what the role of the arbitrator is. We've all looking at Arbitration Act as an Arbitration Act, forgetting that it also talks of conciliation, where the arbitrators also can have a role of bringing the parties together, at least on issues where there can't be a dispute. So the whole purpose of arbitration will be achieved if for instance, the bar, I've said this earlier, that if members of the bar treat arbitration only as a source of an additional income, then the whole point is lost. Because if you say that we will have our arbitration proceedings after court hours in the evening, then the whole purpose is lost, because you will go there after your day-long court work. You are tired. Perhaps the arbitral tribunal is also tired because it's evening. So all that happens is another date, which is something which we say that we are suffering in the classic court system. And that's the reason why we want to move out to an alternative dispute redressal mechanism. But if we don't change our attitudes, then we are running down the arbitral process. And the whole purpose of enactment of the Act, and particularly the 2015 amendments, will be completely lost. Thank you for the time that you've given me. Mr. Thakkar will discuss with you Section 37 of the Arbitration Act. Should I help you with that? Just check. Yeah.
Good evening. I am the last batsman of the day. And in cricket parlance, the last batsman is always a bowler. But I promise you I will not throw any bouncers on anyone. And my Lord Justice Pitale, my friend and president of AVI Prashant Releko, my friend Suresh Sabrad, secretary of AVI, senior advocates, the office bearers and committee members of AVI, Mr. Gautam Mehta, chairman of IMC Committee of Arbitration, his fellow committee members, fellow advocates, participants, law clerks, law interns, ladies and gentlemen. It's a great honor and privilege to address this august gathering today, and I express my deep sense of gratitude to Prashant and Suresh for giving me this opportunity to be amongst you today. We have heard Justice Pitale just now, who explained about Section 9 and 17 of the Arbitration Act. Our subject today is 9, 17 and 37. It should be other way around. I speak first on 917 and he should be speaking on the appellate orders. But sorry, I have chosen to speak on 37. So 37 is appellable orders. There are two scenarios of filing appeals under 37 contemplated. 37.1 contemplates filing of an appeal from the orders passed by courts under Section 8 and 9 and 34 of the Act. So 8, 9 and 34 are orders passed by the court. What are the orders under 8? We know, we have seen in the previous session. What are the orders under 16 and 17? 16 also was discussed in the previous session. Orders under Section 34 you have discussed in Justice Kulkarni's session. And my friend Atul Damle took up the subject of 37 arising out of 34. So let me restrict myself to orders under sections 8, 9 and 16, 17 of the Act. Every legal system must strike a balance between finality and fairness. On the one hand, litigants must have access to appellate review where serious errors occur. On the other hand, excessive appeals undermine certainty, delay, and dispute resolution and increase costs. This dilemma is particularly acute in arbitration because parties have voluntarily chosen to have their disputes resolved by arbitration because the civil suits would have taken time, it would have been expensive, and there would have been delay. Therefore, they come for arbitration. But if in the arbitration also there would be interference by court, by number of appeals from various orders, it would lose the purpose for which arbitration was commenced. And recognizing this, the Parliament adopted a carefully calibrated approach in the Arbitration Conciliation Act 1996. And therefore, Section 37 provides very limited rights of appeal for certain orders. Unlike the Code of Civil Procedure, where numerous interlocutory orders may be challenged, Section 37 permits appeals only against specifically enumerated orders, and it uses two very important words, no others. That would mean that appeal will not lie against any other order passed under the Arbitration and Conciliation Act except those mentioned in Section 37. The philosophy of limited judicial intervention is codified in Section 5, which provides that notwithstanding anything provided in any other law for the time being in force, in matters governed by this part, that is Part 1 of the Arbitration Act, no judicial authority shall intervene except so provided in this part. So keeping that in mind, this Act, specifically under 37, whereby 2019 amendment, they added this non-obstant clause, because earlier when this non-obstant clause was not there, we as a council were arguing in appeal courts that no, appeal is maintainable under latest pattern, and therefore also court should intervene. And we would encourage courts to intervene, but several times courts put its foot down and said, okay, no, the word no other still governs. No others was there from the beginning. So, but now they have made it very clear by adding this non-obstant clause to make sure that people don't come in appeal or people don't file appeal where it is not permitted under this Act. So this is a balance achieved between judicial intervention and independence of arbitration. Now, what is appeal? Because now the question arises that is this appeal to be treated as an appeal which is akin to all appeals under Civil Procedural Code? So it is always to be remembered that right to appeal is a creation of a statute, and without there being any provision in a law, no appeal can be filed. All civilized system of jurisprudence envisage the right to file at least one appeal. A citizen has a right to get the matter examined by a superior court or forum, and such a right is in consonance with the principles of natural justice. A mistake, intentional or unintentional, can be rectified only by a superior court or tribunal. An appeal is nothing but continuation of an original proceedings. The appeal, strictly so called, is one in which the question is whether the order of the court or tribunal from which an appeal is brought was right in taking a decision on the basis of the materials placed before it. So right of appeal where it exists is a matter of substance and not of procedure. And when right conferred by a statute is conferred by a statute, it becomes a vested right. So, as per Lord Davey, an appeal is judicial examination of a decision of an inferior court by a higher forum. And according to Holsbury's Laws of England, an appeal is an application to reverse, vary or set aside the judgment or decision or award of an inferior court on the ground that it was wrongly decided or that a matter of justice or law it requires to be corrected. So, we need to examine whether appeal contemplated under Section 37 has such a wide scope. 37 carefully balances judicial supervision and arbitral autonomy. By limiting appealable orders, the provision preserves arbitration as a quick, final and party-driven mechanism, while ensuring that judicial safeguards remain available in exceptional circumstances. Judicial interpretation has consistently upheld the legislative intention of reducing court intervention and expediting dispute resolution. However, certain concerns continue to exist, including delays in disposal of appeals, uncertainty regarding the proper forum, and ambiguity concerning the scope of interim measures. Under the 1940 Act, a broader appellate framework was there, and numerous orders of the court and the arbitrator were susceptible to challenge, resulting in prolonged litigation and substantial judicial interference. It had become a legal philosopher's paradise. The delays and multiplicity of proceedings under 40 Act were among the principal reasons for its eventual repeal. The 1996 Act marked a decisive shift towards finality. Influenced by UNCITRAL model law, Parliament drastically curtailed the scope of appeals. Section 37 was designed as an exception to the principle of finality. When 1996 Act was introduced in Parliament on the basis of UNCITRAL law, there was no provision in UNCITRAL akin to Section 37. UNCITRAL, in its 39th session in 2006, adopted amendment to Article 17 by incorporating Article 17A to 17J. So the compendium which we have received, which contains UNCITRAL law, does not contain this amendment of 17A to 17J. So this is introduced in 2006. So some of the older books of commentary on arbitration act contain the old UNCITRAL, doesn't contain this. Now in 17A to J which they have added, where 17B provides for power of tribunal to grant preliminary orders, which is like now very fondly known as emergency arbitration, particularly after Amazon case in Supreme Court has dealt with arising out of emergency order passed by an arbitrator in Singapore. This has become very famous, and this word is now become familiar with Indian lawyers, because otherwise emergency arbitration concept is not known to us. Briefly, I will tell you, before the constitution of the arbitration tribunal, there is a provision that if you want an urgent ex parte protection order, you apply for constitution of an emergency arbitral tribunal. So maybe arbitral tribunal may consist of 3 persons, and when you have an institution arbitration, the constitution of tribunal takes a lot of time, where parties are given time to nominate an arbitrator, both parties take time in nominating arbitrator. It takes time. So an emergency arbitrator is appointed, and he hears the parties and passes his function is only to pass an interim order, nothing more than that. So that provision is 17B now in UNCITRAL. 17H provides for recognition and enforcement of interim measures ordered by arbitral tribunal. Now, recognition and enforcement of awards passed by foreign tribunals is part of part 2 of the Arbitration Act, where foreign arbitrations and enforcement of their award is involved. But the 17H provides for recognition and enforcement of interim measures ordered by the arbitral tribunal. Now this 17I(1) specifies the grounds upon which recognition or enforcement of such measures may be refused. And these grounds are substantially similar to those applicable to arbitration awards. So 37H is somewhat akin to 37(2), but it operates conversely. In 37, the person who is aggrieved by the order files an appeal, whereas under 17H, person who wants to enforce his interim measure which is granted to him has to approach the court wherever, because the order is passed by the arbitral tribunal. He needs to probably approach the court having competent jurisdiction, because in cross-border arbitrations, an arbitrator may sitting in Singapore pass an order, but it's required to be enforced in India, like in Amazon case. So that application was made to Indian court, Delhi High Court, and Delhi High Court, from Delhi High Court order it went to Supreme Court. So it is converse, and Article 17(1)(2) expressly provides that a court shall not undertake a review of the substance of the interim measure while determining questions of recognition or enforcement. Thus, the model law adopts a consistent approach towards the review of both arbitral awards and interim measures while discouraging judicial intervention on the merits of the dispute. So in India, we have some courts taking different approaches. I will now enumerate them. In the absence of a statutory standard provided under 37 as to in what manner the appeals are to be considered and disposed of, the first approach is to examine interim orders on the grounds similar to those contained in Section 34 of the Arbitration Act for setting aside of the award. The second approach is to treat proceedings under Section 37 as ordinary appellate proceedings and undertake a review of the merits of the case. So Delhi High Court in Subhash Chandra case, a case of 2007, has observed that interference with interim awards passed by arbitration tribunals must remain limited. And on the other hand, in Sanjay Gambhir and Intertoll and the National Highways Authority of India case, courts undertook a detailed examination of the merits of the dispute while assessing the legality of the interim order. And a third line of decisions applied the same standard of review that would ordinarily be applied while hearing appeals against interim orders passed by civil courts. The Supreme Court in 2018 in the National Highway Authority of India versus Gwalior Jhansi Expressway, where the dispute concerned an interim order passed by an arbitral tribunal, which was subsequently upheld by the High Court under 37(2)(b, took a view that if the order is against the fundamental policy of Indian law, it requires to be set aside. So they applied the same principle which were applied for the purposes of recognizing an award, and 34(2)(b)(2), which specifically states that an examination of the fundamental policy of Indian law shall not involve a review of the merits of the dispute, but they applied the same standard for the purpose of deciding the 37 appeal. Now, Supreme Court's decision cannot be regarded as having conclusively settled the issue because the court did not expressly analyze the relevant provisions of the Act or discuss other grounds that might justify interference under 37(2). So ultimately, we are again left to decide how do we interpret the word appeal. Section 37 employs the expression appeals, whereas 34 employs the phrase setting aside. This difference in terminology suggests that Parliament may have intended a wider scope of judicial scrutiny of the orders which it is required to decide under Section 37. Secondly, the word appeal appears in both sections, 37(2)(a) and 37(2)(b). 2A deals with appeals against the orders relating to jurisdiction under Section 16, which ordinarily require an examination of the merits. Consequently, it may be argued that the same meaning should be attributed to 37(2)(b). So ultimately, we do not know how court will finally determine what is the scope of appeal under 37(1) and 37(2), and how much court should interfere with the decisions taken by either the court or by the arbitral tribunal. From my practical experience, I can say that interference by court under 37 will depend on the nature of the order appealed against and facts of each case. In discretionary orders, unless the order is perverse or no reasonable person would make it, there will or should not be any interference with the orders of the arbitral tribunal. There is very interesting line of judgments one finds wherever it is not provided that an appeal can lie under 37, people have filed a petition under Article 226, 227 before Constitutional Court. Now, there is a judgment of the Supreme Court, Justice Ramanna's judgment, says that writ petition is maintainable. There are two other judgments which says that if there is an alternative remedy, writ petition is not maintainable. Similarly, there are orders of the arbitral tribunal which are not appealable under 37. People have again filed 226, 227 petitions. Bombay High Court had occasion to deal with such questions. Justice Ribello has delivered a judgment in which he has said that he converted an arbitration petition saying that it doesn't fall under any of the sections and I'm converting into writ petition, and he passed an order exercising 227 powers. There are two other petitions filed to my knowledge where I have appeared in the matters, and some orders are passed, but Delhi High Court has held that a writ petition is maintainable, but that power will be exercised very sparingly unless it is found that order passed is a perverse order, or there is a order passed in bad faith, they have used that word. Then only court will interfere under arbitral tribunal's order. And therefore only court will interfere under 227. But this question is required to be settled once and for all. In 2025, a matter came up before bench of Justice Pardiwala and Justice Mahadevan, arising out of Andhra Pradesh, where a bank guarantee was invoked, and that order was restrained order of the refusal of the arbitral tribunal to give injunction was carried in appeal, carried by a writ petition straight away to the division bench. And division bench said, no, the matter is to be heard. This is only an ad interim order, a refusal of ad interim order. Okay, we will grant you injunction, go for a hearing. The matter went to Supreme Court. Supreme Court has framed questions of law A to H. They have recorded arguments of both sides. But without deciding any of the questions, they say, since the matter is remanded back to the arbitral tribunal, we are not deciding the question, but we are dismissing SLP. So they have kept this question of law open. So whether Article 226 or 227 is a remedy to challenge the orders of the arbitral tribunal is required to be finally settled, at least at the High Court level and then ultimately at Supreme Court level, so that these petitions are not filed anymore. With this, thank you very much. Before parting with this, I must thank Pinky Bhansali and her team. The compendium which Justice Pitale referred to, I believe it is given to each and every speaker who was speaking from morning till evening today. So a very big hand to Pinky and her team for doing so much research and assisting everyone for this. And I also want to thank my interns, Khushi and Nidhi, for helping me out. Thank you very much.
With this, we now open the session for questions. Again, the disclaimer, very brief, and only if there is a question. Anyone? There.
Only above.
Everybody is satisfied since morning. They have got so much done.
I think then there are no questions. Are there? Yes, please go ahead, ma'am.
Hello, sir. This is Drishti Diora. I had a question. You addressed Section 9, Subclause 2, and said that there's a time limit of 90 days for the party who has gotten an interim relief to move a Section 21. My question is that the purpose of this is to ensure that the parties don't sit on an interim order which is in their favor. However, the problem with the interpretation that the commencement of the arbitration is only 21 and not 11 is that the parties can serve a notice under 21 and also not move an 11 for the next 3 years, which is the limitation between 21 and 11. So how do we address that?
My mic is on. I believe the party that receives the notice is now put to notice that arbitration is to be commenced, correct? And if the party which has given the notice doesn't go ahead, the intention is clear that the arbitration is now commenced because that's the law, that's the settled law. Nothing prevents the party that is suffering the interim order to move the Section 11. It has to move, somebody has to trigger the process. The whole point is that one who is sitting over the interim measure, order of interim measure, by this interpretation is at least mandated to commence the process, show the intention. But if the party which is suffering the interim order doesn't want to go in for arbitration, then the arbitration process has commenced. It has to be, either it says that I don't agree with your notice, I don't agree with your arbitrator, so let's go to Section 11. So it is triggered. The point is, somebody has to trigger it. It can't be left at loose like this.
Okay. Yes, sir. Thank you.
Do we have any other questions?
Yeah.
Can you please? So we will quickly come to you after it.
No, I thought the guy on the camera wants to ask.
Sir, court can direct the arbitration tribunal to the fast track mechanism or time bound.
No, this, correct, there is a provision, Mr. Thakkar is right, because see the whole, if you look at the act, it says after completion of pleadings, it has to be completed within 1 year, within 12 months. Otherwise, 29A or what is it, substitution of the arbitrator, that provision is there.
No, sir, there is another provision of fast track arbitration, where parties must agree that they will not lead any evidence. And they will only go by argument.
Correct, only by...
It will be done by 6 months' time.
Yes, yes.
There is a provision of fast track arbitration under the Act. So there you can do it expeditiously without 6 months.
I believe it's 6 months.
6 months, yes.
It is 6 months, yes. So one last question, we'll take yours and then we'll take the rest for the day.
My lord, my question is regarding the statutory arbitration, where the authorities appoint the arbitrator. Is that the disclosure under the because the statutory arbitration is also governed by the Arbitration Act. So disclosure is, which was held from the Hon'ble High Courts and this Apex Court, the mandatory. So statutory arbitration, the arbitrator is mandatorily provide the disclosure to a parties, because generally that process keep during when the arbitrator is appointed under the statutory arbitration. I enlighten the my lord.
See, one is it is beyond the brief that was given to us. That apart, the statutory arbitration has a lot of problems, not just this that you are indicating. One of the problems which is now festering, and now recently, last week, the Attorney General has made a statement before the Chief Justice's Court and Supreme Court about, for instance, in the context of the National Highways Act, the arbitrator is a government officer, state government officer, correct? Divisional Commissioner generally or the collector is the arbitrator, where there is a serious issue of bias that comes up. But then the Chief Justice's Court said to the Attorney General that do something on the legislative side, ask the Parliament to do something about it. So the statement made by the Attorney General is that we are coming up with a comprehensive proposed arbitration which will try to address all these issues, particularly the problems faced by statutory arbitrations or institutional arbitrations, etc. So we'll see how this, a lot of things, see, this is like a work in progress. You will see how, if you remember the Sawmills judgment, the Sawmills judgment had opened all the doors. The Section 34 court had become like a first appeal. And I remember Mr. Nariman used to always criticize this judgment when I was practicing in the Supreme Court. Every opportunity he got, he used to hammer the court and say that, sir, you've destroyed the Arbitration Act. But it took a good, I think, 15 years for the amendment to come in 2015 or more. So therefore, the whole point is that all of this should be brought before the Parliament. And more importantly, the Parliament should discuss this and bring about an amendment. You know what is happening in Parliament nowadays. So discussion.
One more last issue, my lord. One more last issue in respect of the same statutory and the institutional arbitration. Generally, when we come before the High Court under Section 11, so High Court have the panel, and according to a quantum of the matter, generally High Court have the seniority of the panel, the retired High Court, former High Court judge, or the district judge, or the advocate. Generally, can that similar kind of hierarchy is required under the statutory and the institutional arbitration? I request Honorable Bar and enlighten from the bar and the bench both, if that can be enlightened.
Yes, my lord. Justice Pitale said about that this requires legislative amendment. So as and when it happens, we will see. In the statutory arbitration, how it's to be done. Supreme Court is considering this matter as it was mentioned just now. So let us see.
Obliged, ma'am.
Thank you, gentlemen.
Somebody
And-
else wanted to ask a question.
Somebody?
The last
Was
one.
it? Oh, yes. Can we please have the mic there?
Section 9 post-award. Can it be said to be,
Can you
it
please
can be
repeat
used
your
as a
question?
tool?
Sorry, can you
Kindly
repeat
repeat.
because you didn't have the mic
In-
that time.
I'm sorry. In view of the recent judgment of the Honorable Apex Court, which gives the right to the judgment debtor to move Section 9 after award, can it be used as a tool to get away from the clutches of the conditions that could be put under 34 when they seek stay? Ultimately, for example, if it is the certain money dispute, under 34 akin to 41(5), the conditions can be put to evade that, whether, can it
No,
be
but if
used
you
as a-
look at, even if you look at the latest judgment and an unsuccessful party can go, the drift of the judgment is that if it's an unsuccessful party, the reason why it will move a Section 9 petition is to preserve the status as it is. If a Section 9 court
No,
should
if
be
it is
able...
a money claim,
If it's
yes.
a money claim, obviously it has to be a 34 with a interim relief application. Here it's more for preservation of the status on the date when the award is given, so that the unsuccessful party moves the 34. We know there's a bit of an overlap here, but the Supreme Court has concentrated only on the words used under the statute and said that this artificial distinction can't be made between a successful and an unsuccessful. But it's for the Section 9 court to decide in discretion what is to be granted. Mischief can be easily found out by the court. The only difficulty here is that from the point of view of the court, the Section 9 court is unnecessarily burdened in this interpretation. The unsuccessful party also rushes there. Yes. And it also goes to the Section 34 court. So there's a bit of a overlap here. But the interpretation is based on again, as we say, some solution has to be found out. It again lies at the door of the Parliament.
Thank you, sir. Thank you.
Anybody else? If
Excuse me,
after today,
sorry.
I'm sorry.
Sorry.
Which
On
way?
the balcony.
Yes, yes.
Okay, please. Yeah.
Sorry. Good evening. Section 29A, this question is related to your lordship. Section 29A prescribes a limitation of 12 months for completion of the arbitration. Now 23(4) also prescribes that the pleadings have to be completed within 6 months. But at times what happens is when a section 16 is moved or section 17 is moved, that itself takes at least about a year to get decided. So the 12 months period which is prescribed under section 29A, I believe that does not meet the 12 months period what has been mentioned. So is there any way that section 17 can also be said to be decided in a time-bound manner? Because when a receiver is appointed or an injunction is granted in the favor of a claimant, that itself may be the pleading, completing the reply, rejoinder, so and so, it itself takes more than a year or for it to get decided, or the receiver to file the report. So maybe any SOP or any prescribed limitation.
No, you're right, but the court can't legislate. You're
Right.
saying, can section 17 have this? By all means, let it be amended, let this be engrafted there, but there won't be a foolproof solution until and unless the litigants, the parties who agreed for resolution of dispute by a private tribunal, are honest in at least proceeding in the arbitral tribunal. There is dishonesty of the litigant, there is dishonesty of the advocates, then the whole system crumbles. You can't put everything at the door of the court. It's the conduct of the parties. At least be fair and fighting with each other.
Right.
If after today, fewer Section 9 petitions are filed rather than, or in cases where Section 17 can make, I think this tribunal, these speakers will definitely rightly claim that the session has already left its mark. As we conclude the final technical session of day 1, may I, on behalf of Advocates Association of Western India, express our deepest gratitude to Honorable Justice Manish Pitale and Shri Nitin Thakkar, Senior Advocate, for sharing their invaluable learning and practical wisdom. Today's discussion has reminded us that interim protection is not an exception to arbitration. It is one of the essential safeguards that ensures the arbitral process remains fair, effective, and meaningful. Your Lordship and Sir, your guidance has enriched not merely our understanding of law, but our appreciation of its practical application. We remain deeply grateful for your gracious presence. Ladies and gentlemen, kindly join me in appreciating the warm round of applause, Justice Manish Pitale and Justice Mr. Nitin Thakkar. I now request the committee members to kindly come forward and felicitate the chair.
They are found as worthy of felicitation. We did our job.
Mr. Sukumar and Mr. Rakesh Watkar, may I kindly request you to felicitate Honorable Justice Manish Pitale. Mr. Sukumar Ganwat, kindly felicitate Mr. Thakkar.